Garden State GSCLE. 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 Garden State GSCLE.
The seminar is, what are we talking about? Search and seizure law for the 21st century. This was triggered as a result of the United States Supreme Court's decision in Riley versus California from a couple weeks ago. And I'm concerned that all of you recognize this case as a landmark decision, not only in terms of the substance of what this particular case was about, but it's really kind of the court's announcement about how they're going to be treating digital type searches into the future. They're kind of getting everybody ready for the tests that they're going to be utilizing to determine whether you have an expectation of privacy in certain digital information, and how they will make a determination about whether or not certain types of digital information is protected by the Fourth Amendment. Now, it's important you know all this because you're going to get digital type cases along the way that it's going to be necessary for you to argue these things in anticipation of the United States Supreme Court ruling or the New Jersey Supreme Court. So this is going to give you the tools necessary to understand how to kind of frame these things. So having said that, let's get started. Just as a couple of introductory remarks, this is the wording of the Fourth Amendment. And notice that, or just you guys will remember that the New Jersey Constitution of 1947 in Article 1, Paragraph 7 has precisely the same wording. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So right off the bat, you can see that the Constitutions, New Jersey and United States Constitution, by their very wording, only outlaw one type of search, and that is an unreasonable search. So if the search is deemed to be reasonable, basically police can do any type of search that's reasonable that they want. It's only those searches that are unreasonable that are barred by the Constitution. Now, when we talk about reasonableness in the context that I've just brought up, there's really three different ways that the police have to act reasonably, and all of them are going to be in play in these cases, so I want to kind of go through them right now by way of background. How do the police act reasonably? Well, number one, the starting position is that the activity of the police has to constitute a search or a seizure within the meaning of the Fourth Amendment. Typically, this is going to be an area where you have a legitimate expectation of privacy, some type of area or thing for which society is prepared to recognize that you have a legitimate expectation of privacy. Once the police are searching in an area where you have an expectation of privacy or a thing that's covered under the Fourth Amendment, in other words, their activities constitute a search within the meaning of the Fourth Amendment, the police act reasonably in three different ways. First, it is reasonable for the police to conduct a search within the meaning of the Fourth Amendment when they have gotten prior judicial approval to conduct that search. Now, typically in New Jersey, prior judicial approval will be one of three things. Either a search warrant, which will be the most common way of doing it. Number two, a grand jury subpoena, and number three, a criminal action order out of the Superior Court. In each one of those instances, a judge will have reviewed the allegations of the prosecutor, of the police, and made a determination that there is probable cause, and then will give the police permission to go out and conduct a search and confine the search to those areas that are reasonable for the execution of the search. Time, place, manner, things like that. The second way the police act reasonably when they're dealing with a search within the meaning of the Fourth Amendment is as follows. If they don't have prior judicial approval, they will still be reasonable if the search fits within one of the recognized exceptions to the warrant requirement that has been developed by the United States Supreme Court over the years. So search incident to an arrest or exigent circumstances, consent, there's probably 30 different exceptions that have been developed over the years. All these exceptions are given to us by the United States Supreme Court. That's the only body that can come up with an exception to the warrant requirement. And as a result of the police, their conduct fits within one of these well-defined, well-delineated exceptions, they will have acted reasonably. The third way the police act reasonably deals with the way they go about conducting their search. Just to give you a couple examples, what's the name of the case I told you to never forget because I can never remember?
Broward versus Inyo County.
Thank you very much. Broward versus Inyo County is a typical example of this, where the police are on a high-speed pursuit of a young fellow on a motorcycle. They can't stop him. They just can't bring the case to an end. So the police decide, in order to terminate the chase and terminate it with extreme prejudice, there's a kind of a windy road that the drivers can't see around, and they set up an 18-wheel truck across the roadway so that this young fellow on the motorcycle, basically, his day is going to come to an end very quickly. Now, I've seen this in the movies 1,000. Lenny, you've seen this in the movies. You know, you're on the guy's on the motorcycle. He sees the truck.
He lays it down.
You lay it down, right? You slide up, and then get up and take off again, right?
Jack did it.
That was back in the 20s. I'm talking about like current day. So, yeah, we've all seen that. Now, that happens in the movies. In real life, what happens is the guy gets killed. Right? And that's what happened in this case. So, the preliminary issue for the court to decide was whether or not a roadblock constitutes a seizure within the meaning of the Fourth Amendment. Because remember, if what the police are doing is not a seizure within the meaning of the Fourth Amendment, they can do whatever they want. They only have to act reasonably when their activities constitute a search or seizure within the meaning of the Fourth Amendment. So the answer to that question by the Supreme Court was yes, a roadblock is a seizure within the meaning of the Fourth Amendment. And then the next question, of course, is did the police act reasonably by setting up a situation which was almost certain to kill this individual? And that became the subject of a federal civil rights lawsuit. In New Jersey, a good example of unreasonable conduct by the police came about in the case of State versus Ravoto. And I know, Richie, you're familiar with this case. This is the blood case where the police had arrested an individual involved in a minor accident, a drunk driver. They took him to the hospital for the purpose of taking a blood sample from him. And at the hospital, he objected to having blood removed from his body on the basis that he was afraid of needles. The police weren't hearing anything about that and instructed the hospital personnel to strap him to a gurney. And then 6 police officers restrained him while the phlebotomist removed the blood sample. The New Jersey Supreme Court held that level of force, that amount of force, was unreasonable under the circumstances. It was disproportionate to the seriousness of the charge that the defendant had against him. So this particular defendant had just a simple drunk driving case, no criminal charges, but yet the amount of force utilized by the police was extreme in comparison to the seriousness of the charges. Now, the court goes on to say that, in other circumstances, that same level of force or even more force might be reasonable. For example, if the defendant was a suspect in an aggravated manslaughter or 2 or 3, or an aggravated assault that's about to turn into an aggravated manslaughter. And under those circumstances, the police have got to get that evidence immediately. This is going to be their proof of reckless conduct in terms of finding out what the guy's BAC was. So because of this charge would be so much more serious, an enhanced level of force would be reasonable. But just for a regular drunk driving ticket, I don't know that there's any level of force the police could use that would be reasonable under those circumstances. So, and you're going to see this coming up as we discuss these things. Okay, so we're only talking about unreasonable searches. That's the only type that is banned here. Now, this next part is a little bit of kind of soapbox for me. The challenge of the Supreme Court is to interpret and implement these cherished protections in the context of the 21st century, dominated by digital communications and storage. Technology that was unheard of a decade ago, let alone at the time of the adoption of the Bill of Rights. And this is the business we were talking about with Justice Scalia a few moments ago. He is what's known as an originalist, and he always goes back and tries to look at how the framers have handled a particular issue. Every once in a while, that actually there's something in the digital age that comes up where, the framers would have handled it in a very predictable way. We'll talk about that in a few moments. But for the most part, we're dealing with technology literally that was inconceivable 10 years ago, let alone, back in the colonial times. And by the way, this is not my statement. This is the Supreme Court talking about this type of technology just not being in anybody's, horizon a decade ago. Keep in mind, too, and you'll see the Supreme Court is very, very adept at the current level of technology, but also just says, look, on the trend line we're following right now, who knows? I mean, everything is changing so quickly. We have no idea what's going to come down, what marvels and wonders will be available to the general public in terms of digital data and storage and things like that. We just want to be ready for it when it comes. They go on to say the following: you'll see from the following cases, the justices demonstrate a remarkable level of familiarity with all the latest technology and the digital age, as well as its impact on society. When you read these cases over, it's like they know stuff that I never even heard of. I didn't even think about stuff like this. One of the things that was really fascinating to me, they talk about, for cell phone, smartphone storage, apparently there's an app out there where you can press one little button on your phone and it just eliminates forever all the things you have stored on the phone. There's also a remote app so that somebody anywhere in the world could call a particular number, go to your phone, and just wipe out all the memory of it. Okay, like that. Yeah, that's what they're referring to. Smartphones. So they talk about this concept of this particular chamber that you can put things in where the radio frequency can't get in. I can't think of the name of it.
Okay.
It's just from Phil Faraday. We should not have brought him up. See, now it's something similar to that name. But they have a bag, apparently, that the police can take your cell phone, plop it into, seal it up, and it makes the bag, inaccessible to digital signals coming into it, all right? But who knew? I mean, who thought about this kind of stuff? But the Supreme Court actually talks about these things. As a result, the court's rulings are simultaneously rooted in the colonial past and an unknowable digital future that will be dominated by technological advances that are unimaginable in our present era. I want to give you guys all something to think about just so we can look at this in the long term, okay? I'd like to think about the 75 years from 1939 until 2014, okay? And most of us have been around long enough during that time period to have lived through the innovations and changes to society that occurred during that time period. So we think about medicine, antibiotics, weaponry, transportation, communications, education. Think about all the changes and the benefits that have accrued to human beings since 1939. Just air conditioning alone, if nothing else, all right? Fax machines. I mean, just everything that we have now that we take for granted, that none of it existed whatsoever in 1939. And I'd like you to just, in your own mind, just do a little thought experiment. Pick any 75-year period of time ever in recorded history, okay? Go back to minus 10,000 years ago or 2,000 years ago, it doesn't matter. And take any 75-year period of time that you want. And then ask yourself, from point A to 75 years later at point B, did human life really change? Did it really improve? Did anything come along that made human life demonstrably better for everybody? I'm going to suggest to you that the welfare of human beings, especially in first world countries like ours, has changed astronomically in the 75 years from 1939 through 2014, okay? There's never been such enormous change for the betterment of human beings. Where we going to be in the next 75 years? Well, come back and see me in 75 years and I'll try to let you know. But you can just imagine, if you think about things on trend, where we're going and how the change is accelerating, it's really, I suspect it's going to be a pretty remarkable future. I mean, if you stop to think about it, it even affects the way people die, okay? At the turn of the century, back in 1900 and through almost all of recorded history prior to that, human beings died primarily of either accident, homicide, or communicable disease. That's how people died, okay? They got viruses, they got measles, they got all those types of diseases. Infectious disease was basically the big killer of human beings on Earth. That's not the case anymore, at least in a first world country like the United States. People die today, first of all, they live a lot longer on average, but also they die of lifestyle-related maladies of the 21st century. Cancer, okay, and heart disease, and things that are related to diabetes. Again, lifestyle-related causes of death.
Here's to feeling good all the time.
So, I mean, every aspect of human life has changed for the better, at least in first world countries, over the next 75 years, and who knows where we're going to be. But the Supreme Court is tasked with the responsibility for dealing with this in the context of the Fourth Amendment. So let's see how it's going to go. First legal issue we have to talk about is the search incident to an arrest exception to the warrant requirement. And the starting point for that is Schimel. I want to show you a little quick film clip just to kind of illustrate some of the legal issues that are here. And pay close attention to this thing, all right? The film clip you're going to see is from 1966. And so it comes out 3 years before Schimel versus California, but kind of watch what happens. Oh, and also one more thing. This was obviously filmed very, very close after the United States Supreme Court decision in Miranda in 66. So let's take a look at it.
Police Officer Shelton, hold it right there.
Stand still.
Go ahead, pick it up. Got it. Out there. Come on, move. Over here.
Found this switchblade on him, Joe.
By the rust, what's it all about? An ex-con with a gun will do for a start.
All right, put your hands down. Come on. What's this?
Mints. Candy mints.
Yeah, sure. Down a roll of bennies, Joe.
All right, now both of you listen. You're under arrest. You have the right to an attorney. You have the right to remain silent. Anything you say to us can be used against you in a court of law. Is that clear?
Yeah. Okay.
You're sure you understand?
That's right. Neither one of us got any plans to say a word to you yo-yos. You got the message, didn't you, Maxie?
They don't want us to talk.
All right, Markel, in here.
What are we going back in the kitchen
In
for?
there.
I don't know why you're pushing me around for a lousy dollar roll of bennies. It ain't against the law to have a few bennies. Besides, I got a prescription. Same old thing. A guy gets out of stir, you gotta keep hounding him. Hey, talk to my P.O., man. He'll tell you I'm straight. I'm straight. You got nothing on me and Maxie. Nothing. But me and Maxie, we don't have to say nothing. We don't even have to talk to you. You told us. Besides, we ain't done nothing wrong. You can stand here all day and talk to me, but I'm not gonna talk to you. I don't have to. I don't have to talk to you.
All right, Markel. Bill.
You know, Dragnet prided itself, Jack Webb, on having the police there and kind of having proper procedures, I guess one of which was, in this case, breaking the door down without a warrant. But notice how tentative they were here in the sense of, like, today, you know, these guys would be on the floor in handcuffs from head to foot before the police did anything else. Notice that the search of them, incident to the arrest, involved a pat-down, a Terry type of pat-down. Notice that when Jack Webb went in there and he was kind of detaining this guy while he's under arrest, he's conducting a search of the kitchen. And he's looking in drawers, he's looking in cabinets and things of that nature, okay? None of this had really been clarified by the Supreme Court at the time that this happened in 1966. This is what Schimel is all about. These are the issues in the case. So Schimel is going to really deal with this whole idea about what can the police do in terms of searches when they arrest somebody, okay? Let's take a look. Schimel versus California, this is a case that sets the groundwork for most of the existing searches to an arrest doctrine. Police in the case arrested the petitioner inside his home and proceeded to search the entire three-bedroom house, including attic and garage. In particular rooms, they also looked through the contents of drawers, which you just saw in the little clip. When an arrest is made, it is reasonable for the arresting officer to search the person arrested. Now, there's three public policy things that support this. This is not something that's predicated by probable cause. It's predicated on public policy grounds, okay? And here are the three things that support it. Number one, remove weapons that the letter might seek to use in order to resist arrest or effect escape. Now, this has been changed a little bit, so there's really kind of two things. This one becomes two. Remove weapons that could harm the officer. Number two, remove implements of escape, which could be a weapon, it could be a handcuff key or something of that nature, all right? And finally, and they go on to say, officer's safety might well be endangered and the arrest is frustrated. In addition, it is entirely reasonable for the arresting officer to search for and seize any evidence on the arrestee's person in order to prevent its concealment or destruction. So to recover evidence that the defendant might otherwise conceal or discard. These are the three public policy initiatives that support the search incident to an arrest exception. Now notice that it doesn't tie the arrest, or the reason for the arrest, to the type of evidence the police would be looking for. It'd be any evidence of any crime that might be in the possession of this individual. Sometimes you might have, a murder weapon or something of that nature, or burglary tools, that's fine. But you may have arrested somebody for some petty offense, and he has in his possession some innocuous object that actually ties him to some other crime forensically, okay? And all that is perfectly okay. There is no connection between the type of evidence that the police are searching for and the crime that's under investigation or what the initial arrest was for. This is just a general broad-based ability of the police to conduct a search. The court goes on to say there's ample justification, therefore, for a search of the arrestee's person and the area within his immediate control, the so-called wingspan test. Now, they're placed an area where he could grab some type of a weapon or something of that nature. Construing the phrase to mean the area from which he may gain possession of a weapon or destructible evidence, okay? Now, this is a full-blown search of the individual. This is not a pat-down, which is a limited search of the exterior of the person's body, patting down his clothing. This is reaching into pockets, grabbing, shoes and things of that nature. Many times the police will do an initial search on the street, then a much more thorough search back at the police station, again to recover evidence, weapons, and implements of escape. This is the central holding in Shamel. Now, I'd like to show you a follow-up case that occurred 4 years later, United States versus Robinson, and there's a companion case on it, Gustafson versus Florida. Once again, I want to introduce this with a little film clip, okay?
Entered? How could you enter? The door was locked. You broke down the door without a warrant.
I heard a scream.
You heard a scream. Now, you sure it wasn't laughter? Maybe a bunch of kids having a good time, innocent merriment, something like that?
No. It sounded like a scream to me.
Hit him with the Fourth Amendment, laws.
That's not really appropriate. Fourth Amendment.
You're a law student, right?
Yeah.
Well, don't come on so heavy, Why would I ever hire you? You're coming on so heavy.
I'm sorry.
Okay, so you went inside. Then what happened?
I saw one of the defendants make a furtive movement.
Like what?
You want to demonstrate?
Please.
It was like this here, right here.
That's a furtive movement.
Down into
Okay,
here.
I'd like to demonstrate that movement just like this. That's a furtive move, and you were scared, and then what did you do?
So I searched him.
And what, in fact, did you find?
Pack of Marlboros.
A pack of Marlboro cigarettes. So instead of just realizing you had made a human error and returning the cigarettes to the young man, you decided to peek inside. Why?
Because I'll tell you something. I thought that defendant may have been concealing a small plastic device, exploding device of some kind. So I checked, I opened up the cigarettes, and I checked inside. That's why.
You were looking for a bomb and a package of cigarettes?
Take your seat.
I'm sorry. It's all right, I'm in control. I'm not sure about these people, though.
A bomb and a pack of cigarettes today, given our world, may not be such a crazy idea when you stop to think about it. It's weird how all this stuff kind of changes. There's a New Jersey case on this called State versus Demeter. We probably have the citation for you, involving a stop by the police where they searched the guy and found a little film canister, And I guess, what year is Demeter? About 91? Okay. So in the Demeter case, the police officers, they open up the film canister and they find, what they were looking for, which was marijuana. And they get to the Supreme Court, New Jersey Supreme Court says, listen, sometimes a film canister just has film in it, okay? The fact that he has a film canister, and sometimes people transport drugs in there, doesn't give you a reasonable articulable suspicion or any probable cause to go inside and search that thing. Lots of times people actually have film in the film canister. And again, this is just an example of how life has changed in the 21st century. Anybody who has a film canister in his possession today, I'm going to tell you something, it has drugs in it, okay? Nobody uses film anymore. So Robinson is the second in a trilogy of cases dealing with search incident to an arrest. Robinson and the companion case Gustafson both involved cigarette packs and searches of cigarette packs, okay? And just like you saw in the little motion to suppress vignette there, in each of these cases, there was a search of a cigarette pack. But the difference is, In the vignette you just saw, this would be a kind of a Terry frisk, because remember, the guy was under arrest. He was searching it because he was fearful that there was some type of exploding device in the cigarettes. So it was more of a Terry frisk than anything else. In Robinson and Gustafson, this search was predicated upon an arrest. In other words, the person was in custody, being arrested, and now being searched incident to the arrest. The police find the cigarette pack, then they go inside the cigarette pack, incident to the arrest, and find drugs. Here's what the Supreme Court said in Robinson, and the holding in Gustafson is identical. Following a lawful arrest, a police officer searched the interior of a pack of cigarettes in possession of the respondent. The court concluded that the search of the respondent was reasonable, even though there was no concern about the loss of evidence, and the arresting officer had no specific concern that the respondent might be armed. In so doing, the court did not draw a line between the search of his person and a further examination of the cigarette pack found during the search. It merely noted that, quote, having, in the course of a lawful search, come across a crumpled pack of cigarettes, the officer was entitled to inspect it. And when he did, he found that type of contraband inside. So, getting back to what you indicated before, it appears that when the police effect a lawful arrest, they're going to be able to search the person and any contents that are found, containers on his pocket. And I guess that would include purses that women would hold, or men for that matter, wallets and things of that nature, certainly cigarette packs and other containers in their possession. A few years later, the court clarified this exception that was limited to personal property immediately associated with the arrestee of the person. There's a case called Chadwick, and I think the guy was lugging behind him a 200-pound trunk, like a steamer trunk, okay? They arrested him, and then the police went into the steamer trunk incident to the arrest, and the Supreme Court said, no, that's way beyond the scope of what we intended. It's not likely when the guy's under arrest, he's going to be able to go into a locked steamer trunk and take out some type of a weapon. The steamer trunk's going nowhere. It's totally within the control of the police. They want to get inside of it. Under those circumstances, they should have a warrant, okay? Couple of additional cases I want to bring to your attention. Again, Gusta, we mentioned. Atwater versus City of Lago Vista is a case where the woman was arrested as a result of a traffic violation, and it might have been seatbelt. She might have been not wearing a seatbelt, as I recall. But the key is it was the most minor of motor vehicle offenses, had a very small fine, and no jail component associated with it. But the officer made a custodial arrest, actually took her into custody, and the Supreme Court said that that was okay, arresting her under those circumstances because he had probable cause. What authorizes the seizure of another human being, an arrest is a seizure within the meaning of the Fourth Amendment, is the establishment of probable cause. Once he has probable cause, he can go about conducting that type of a seizure, and of course, if he's going to search instant to the arrest, okay? Now, the third in the trilogy of these cases is Arizona versus Gant, and this is a very, very unusual, I think it's another Scalia opinion. It's really kind of a remarkable decision when you come right down to it, and it requires a little bit of discussion. This is the case where the Supreme Court reversed itself, vacating its holding in New York versus Belton. Now, New York versus Belton is a 1981 decision, and I don't care what the Supreme Court says. I'm telling you how everybody interpreted it, but only for 30 years. What happened was the Supreme Court in Belton takes the search incident to an arrest exception and plops it into the realm of motor vehicles. And the holding of the case was that when the police arrest a recent occupant of a motor vehicle, they have the authority, incident to the lawful arrest of that recent occupant, to go into the vehicle and search it. Why? All the same reasons you'd have under Chamel. Recover weapons, implements of escape, and evidence that might be inside of the vehicle, okay? And I have to tell you that for years following Belton, the police just really recovered, untold tons of drugs and guns and all kinds of crazy stuff from cars when they went in and searched it incident to an arrest of a recent occupant, okay? Now, the rule in Belton was subject fairly early on to what became, I guess the only way I can describe it is withering criticism from legal scholars around the country initially, and then from courts of appellate authority later on, that it was just way too broad and provided the police with way too much power. They also pointed out, the critics of the case said it really doesn't make any sense in this, when you stop to think about the whole process. The police arrest the driver, for example, of a motor vehicle, place him in handcuffs, walk him back, put him inside of a police car, handcuffed in the back, and then go back to the vehicle and conduct a search, okay? Well, there's just no possibility of someone who's in custody under these circumstances from getting back to his car, searching it, destroying evidence, grabbing a weapon, getting some handcuff key or something like that. It's not going to happen. So it kind of defeats the whole purpose of having a search incident to an arrest of a vehicle when the individual is already out in custody and immobilized in the back of a police car. The New Jersey Supreme Court, for the Appellate Division initially, and then our Supreme Court, was really concerned about it, not in the sense of how ridiculous it was, but they thought that it just provided too much power to the police to conduct searches. And what they were really afraid of was that the police would effect arrests for very, very minor offenses. I think there's a statute, 39525, which allowed the police to arrest individuals for any offense that's in Subtitle I that's committed in their presence. So you could be arresting people for 39329 violations, 39334, driving your horse across the sidewalk at more than 4 miles an hour, 394-100, my favorite statute. But any of these really technical minor violations, equipment violation, tail light out, whatever it could be, the police have the lawful statutory authority to arrest individuals who commit those offenses when they're either committed on view, in the presence of the officer, or there's an admission that the individual has committed the underlying offense. The custodial arrest would then, under Belton, allow police to conduct a search of the vehicle incident to the arrest. And that was scary to the Appellate Division. The initial decision criticizing this was written by the late Judge Pressler in a decision called it was captioned State versus Pierce. And in the Pierce decision, the Appellate Division criticized this statute. And then later on, when the Supreme Court picked up on it and affirmed the decision of Judge Pressler, they just kind of created this new rule which said, look, statutorily the police can conduct these types of arrests, okay? But we are not going to allow police to conduct a search of the vehicle instant to the arrest when they're arresting people for minor motor vehicle violations, okay? I mean, if it's for something important like driving on the revoked list or drunk driving, something of that nature, that's fine. But for these minor motor vehicle violations, we're not going to count in searches of motor vehicles because they just felt that it would allow the police to come up with arrests just based on these pretexts, a pretext for a search based upon a very minor motor vehicle violation, okay? Now, the end came, mercifully, I think in 2005 was the initial publication of State versus GSCLE. GSCLE was kind of funny because the Appellate Division knew that they were going to be releasing an atomic bomb on law enforcement community. So they waited until the last week of the year, and literally between Christmas and New Year's, when nobody's paying attention to anything, they released it like on a Wednesday in the middle of the week. It was the only case that was released all week long because I think they just wanted to, keep a very low profile. And what they did basically was say, Belton is no longer part of the fabric of New Jersey law. Our Constitution, the state Constitution, will not allow us to continue with Belton. It's just an abuse, basically, for the police to be able to do that. The decision was appealed. It went to the New Jersey Supreme Court, and the New Jersey Supreme Court affirmed the decision of the Appellate Division the following year. GSCLE's kind of an interesting case, too, by the way. When you read it over, the search that the police conducted would have been sustainable under 3 or 4 different exceptions to the warrant requirement, okay? The police had all kinds of reasons to get in to search this guy's car. But what was interesting about the case is that the Attorney General did not brief or argue any of the other reasons. They wanted to force the issue. So they limited their argument in the case just to the search incident and arrest, just to Belton, and ignored all the other reasons why they could have gotten into the guy's car. So I guess surprisingly they wound up losing kind of badly. So the publication of GSCLE by the Supreme Court, first by the Appellate Division in 2005 and then later by the Supreme Court in 2006, that was the end of Belton in our state. And that exception of the warrant requirement does not apply anymore in New Jersey. The United States Supreme Court finally got caught up to the rest of the country, and in 2009 came out with Arizona versus Gant. Now, in Arizona versus Gant, basically what the Supreme Court does is they reverse their holding in the Belton case. They're very snarky about it, too. When you read the case over, they basically say, look, everybody in the country has been wrong. We never intended that. You guys have misread and put in too much emphasis on our decision in Belton. We never intended that. That was not what we meant. Well, okay, but thanks for telling us after so many years after the fact. They create one limited exception to the search incident to an arrest for an automobile which I have to tell you, I'm an expert in this because I watch Cops on TV every night. Everything I know about law enforcement is from Cops, okay? And when I see the cops like grabbing somebody out of a car, you know, they don't allow the guy to stand around the car and like look in while the cops are searching. These guys are on the ground, handcuffed head and foot, or they're in the back of a police car somewhere, banging their head against the window, okay? I see this on TV. Take a look at this. Starting in 1981, the case law held the police could conduct a full automobile search to recover evidence, weapons, and implements of escape following arrest of recent occupant. That's Belton. The view became subject to withering criticism in the following decades by legal scholars and appellate courts, rejected by the Supreme Court of New Jersey in 2006 under our state constitution. Now, as I've indicated, the court grudgingly eliminated this categorical exception to the warrant requirement in 2009 with the Gantt decision. But take a look at their language here. This is so funny. Gantt, like Robinson, recognized that Schimel concerns for officer safety and evidence preservation underlined the search incident to the arrest exception. As a result, the court concluded that Schimel could authorize police to search a vehicle only when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search. I'm telling you, this never happens. It never would happen, okay? It's just never going to happen. When the police arrest somebody, I mean, just the most basic police training is they're gone, they're history, all right? They're in the officer's control and not going to be in a position to jump into the car. Gantt added, however, an independent exception for a warrantless search of the vehicle's passenger compartment, quote, when it is reasonable to believe evidence relevant to the crime of arrest might be found in the vehicle, close quote. So I guess you've like arrested the guy on a warrant for drugs. I guess theoretically you could go into the car and search for those drugs. There's some rational nexus between the search and the purpose of the arrest. I wouldn't be trying that if I were a law enforcement officer in New Jersey. I don't think our Supreme Court would countenance that type of a search, at least under this exception to the warrant requirement. I don't know that there is any utility or anything left of the search incident to an arrest exception for automobiles in New Jersey at all, given how strong the court's position was in Eckel. The court goes on to say that exception stems not from Schimel, court explained, but from the circumstances unique to the vehicle context. Now, I want to talk for a couple seconds about the search incident arrest law in New Jersey, so you're going to see how this issue is going to play itself out in the digital age in a moment. But I just want to trace for 1 second how New Jersey has dealt with this. Again, you could pick up from what I said before when we discussed the Pierce case about the court's concern, both at the appellate level as well as for the Supreme Court, for abuse by the police in terms of arresting people on minor charges. This kind of came up all of a sudden in a case called State versus Dangerfield, case that went from the appellate division to the Supreme Court. And Dangerfield involved, here are the facts, the police are kind of patrolling a public housing project. They see a young fellow on a bicycle, ask him what he's doing there. He gives some lame excuse to what he was doing there. The police aren't buying it, and they wind up arresting him for defiant trespass, petty disorderly persons offense, okay? They then get him off his bicycle, search him, and find drugs, okay? So now the issue in the case was the police conduct in searching him incident to that arrest reasonable? Because there are no, there's no physical object that you could possibly have in your possession that is going to be probative on the issue of defiant trespass. There's just nothing there. So I mean, the whole case is predicated upon the fact that there'd be a nexus between the search of the individual and the offense that you've kind of arrested him for in terms of that type of evidence. So the Supreme Court, they're very uncomfortable with this idea about people being arrested for minor offenses and search incidents to the arrest. They decide to take a kind of a middle position, and they looked at the court rules at the time, and the court rules that were existent at the time Dangerfield was published held that when the police could effect a custodial arrest, they're required to take the person back to the police station for post-arrest identification procedures and other processing, booking procedures. The court said, we're going to amend our court rules so that it's not going to be necessary for the police to take someone back to the police station anymore. What we're going to do is say, police, you can process them out on the street, give them a ticket, charging them with a DP or petty DP or an ordinance violation, whatever it's going to be, and send them on their way. The requirement that you no longer have to take them, or the requirement that they be taken back to the police station for processing is out. You can just release them on the street. There's no need under those circumstances to conduct a custodial or search of these individuals incident to the lawful arrest, okay? So that was kind of their solution to this problem that they're very uncomfortable with. Daniels came out 5 years later, and Daniels really kind of answered the last piece of the puzzle that had been left out of Dangerfield. What is the nature, if the police are going to do a search, what can they do? Especially in a situation where there's no physical evidence. Are we talking about a pat down of the individual? Are we talking about a full bodily search of the individual? The amazing thing about the Daniels case when you read it over is that the facts in Daniels are identical to the facts in Dangerfield. I think it was even the same police, actually. Same housing project, same young man on a bicycle riding through the housing project, same getting stopped by the cops. What are you doing here? Same charge of defiant trespass. In other words, an identical case. Probably even the same drugs. But Appellate Division finally and grudgingly says that the search of the individual can be a complete search, not only of the individual but also of any containers that he has in his possession, basically kind of following the philosophy set forth in the Robinson case. And they're not happy about it, but that's just the way it's going to be. So kind of keep this in the back of your mind that this is not a particularly, especially for petty offenses, not a particularly popular exception to the warrant requirement in the New Jersey judiciary. So that brings us to Riley versus California. What are the facts of Riley? I think Riley's, I recall, was a traffic violation they stopped the guy for, okay? Bring him out of the car. I think he's on the revoke list. They arrest him. They search him into the arrest, and what do they find in his pocket? They find this right here, okay? The police seize it. They start looking at it, looking at the files on the phone. And one of the things that gets their attention very quickly is they see this initials coming up all the time, CK, Crip Killer. Okay, that's what CK, in their experience, that's what CK stands for. So that signals to them that they have somebody here who's into the criminal justice system, so to speak. So they start going through his numbers, they start kind of putting things together, they start looking at some of his photographs, they see him photographed with gang members, known gang members, people who have gang affiliates, and they keep looking and keep investigating and keep looking and keep investigating, and ultimately they put enough together to tie this guy to a homicide, all right? All from his cell phone. Prosecute him, he's convicted, and now the issue becomes whether or not it was reasonable for the police, A, to seize the cell phone, and B, to search the contents, the digital contents of the cell phone instance of the arrest. Now, there's a very strong argument following Robinson and Gustafson, the cigarette pack case, that this is, perfectly acceptable for the police to do. If they can look inside of a cigarette pack, why can't they look inside of your cell phone? Isn't that really kind of the same thing and for the same purpose, to recover evidence? This is the issue before the Supreme Court. Remember, as I told you before, this is a unanimous decision. Take a look at what they say. First of all, the first thing you have to understand is this is the first time that the court has analyzed Schmel to a search for the contents of an item on the arrestee's person. In the Robinson case, they looked, going inside of it, that's fine, but now we're talking about the actual contents that you seized from the individual incident to the arrest. Here's what the justices say. These cases require us to decide how the search to arrest doctrine applies to modern cell phones, which are now such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude that they were an important feature of human anatomy. A smartphone of the sort taken from Riley is unheard of 10 years ago. A significant majority of American adults now own such phones. Cell phones differ both quantitatively and in a qualitative sense from other objects that might be kept on an arrestee's person. The term cell phone is itself misleading shorthand. Many of these devices are in fact mini computers that also happen to have the capacity to be used as a telephone. They could just as easily be called cameras, video players, Rolodexes, calendars, tape recorders, libraries, diaries, albums, televisions, maps, newspapers, or, for GPS, I guess you call them, satellite links or something of that nature, okay? And who knows what they're going to be in the future. One of the most notable distinguishing features of a modern cell phone is their immense storage capacity. Before cell phones, a search of the person was limited by physical realities and tended as a matter to constitute only a narrow intrusion on privacy. Most people cannot lug around every piece of mail they have received for the past several months, every picture they have taken, or every book or article they have read, nor would they have any reason to attempt to do so. If they did, they would have to drag around them a trunk of the sort required to hold, that required a search warrant in Chadwick. Remember I told you about the Foot Locker the guy was dragging around? Rather than a container the size of a pack of cigarettes in Robinson. Now, here, this is very important, this next paragraph. This is going to be the rule, and you're going to cite this to the Law Division and the Appellate Division when you get one of these digital searches, okay? Absent more precise guidance from the founding era, we generally determine whether to exempt a given type of search from the warrant requirement by assessing, on the one hand, the degree to which it intrudes upon an individual's privacy, and the other, the degree to which it is needed for the promotion of legitimate governmental interests. So that's the balancing test that you're going to argue, okay? And I'm going to give you several cases where this comes up. Such a balancing of interests supported the search incident to arrest exception in Robinson, and a mechanical application of Robinson might well support the warrantless searches at this issue. I have to tell you, one quick thing we should talk about real fast is a case that's before the New Jersey Supreme Court right now dealing with urine samples, okay, requiring people who've been arrested to give a sample of their urine for testing purposes. The current New Jersey case law out of the Appellate Division, which I don't know that's good anymore, a case called State versus Malik, M-A-L-I-K, authorizes this type of search as a search incident to an arrest, okay? It may be that the Supreme Court is going to require a warrant, taking a look at this, determining whether the search warrant requirement, they assess on one hand the degree to which it intrudes on the individual's privacy. And there's ample case law to suggest that biological activities by human beings are entitled to an enormous amount of, they have an enormous expectation of privacy, weighed against the need for the promotion of a legitimate governmental interest, which in this case would be to see whether or not you've had consumed recently some type of CDS or medication or alcohol, whatever it may be, that would have affected your driving. So we'll see how the court rules, but that's the type of balancing test that they're going to utilize to render that decision in the case. It's called State versus Verpent. The court goes on to say such a balancing of interest supported incident to arrest, exception in Robinson, and a mechanical application of Robinson might well support the warrantless arrest at issues here. So if they wanted to take the shortcut, they would have said, listen, this is exactly the same as a pack of cigarettes, the police can do it. But they're not ready to do that. Here's the distinction. While Robinson's categorical rule strikes the appropriate balance in the context of physical objects, neither of its rationales has as much force with respect to digital content on phones. On the government interest side, Robinson concluded that the two risks associated with Schimmel, harm to the officers and destruction of evidence, are present in all custodial arrests. There are no comparable risks when the search is of digital data. In addition, Robinson regarded any privacy interest retained by an individual after arrest as significantly diminished by the fact of the arrest itself. We're going to come back to this in a couple seconds in a different context, but I just want everybody to understand that you have an extremely low expectation of privacy following an arrest, okay? Just society is normally not prepared to grant you any legitimate expectation of privacy, except in New Jersey for strip searches, which there's a procedure to utilize by the police. The court goes on to say, cell phones, however, place vast quantities of personal information literally in the hands of individuals. A search of information on a cell phone bears little resemblance to the type of brief physical search considered in Robinson. Our holding, of course, is not that the information on the cell phone is immune from search. It is instead that a warrant is generally required before such a search, even when a cell phone is seized incident to the arrest. Our cases have historically recognized that the warrant requirement is an important working part of our machinery of government, not merely an inconvenience to somehow be weighed against the claims of police efficiency. Recent technological advances, similar to those discussed here, have, in addition, made the process of obtaining warrants itself more efficient. Now, I'd like everybody to put a little note in your materials here. This is a direct reference to Missouri versus McNeely, okay, where the court basically talks about, when you're dealing with totality of the circumstances analysis, about how hard or easy it is for the police to get a warrant, recognize that in 21st century America, the cell phones and fax machines and email and Twitter and scanning and all these other types of digital communication are available to the police and to the judges. So the idea that you would have to, you couldn't get a warrant because it was just too time consuming, really kind of flies in the face of the available technology that's around. If you stop to think about 1966, the year that Schmerber came out, Schmerber involved a traffic accident where the cops had to investigate it, then drive the guy to the hospital, develop the probable cause to believe the guy's under the influence of alcohol. The police wanted a warrant. They would have to go to the courthouse and find a judge after preparing all the paperwork, or go to the judge's house after preparing the paperwork and wake him up. All that a very time-consuming process when you're in the face of evidence which is dissipating with every beat of the defendant's heart. Contrast that with the court's holding in McNeely, where they say we would expect that as one police officer is driving the defendant to the hospital, another police officer will be on the cell phone with the local judge making an application for the search warrant, which can be transmitted to the judge electronically. The judge can consider electronically, sign it, and if he signs it, send it back to the police electronically. So by the time the defendant gets to the hospital, all this application for the search warrant can and should be over through the use of readily available modern communication techniques. The court suggested in McNeely, and they go on and they talk about it quite a bit in the Riley case, that they are all over any type of technological development that is going to facilitate communication between law enforcement and the judiciary. Each of them has an important job to do, and that's perfectly okay. They have independent responsibilities. But anything that's going to cause them to be able to interface effectively and quickly and thoroughly, they're all about that. And if it's some type of digital development or something we haven't conceived of that's going to happen in the future, as long as it enhances the communications process between them, that's okay with the Supreme Court. In Riley, the court went on to say the following: moreover, even though the search incident to arrest exception does not apply to cell phones, other case-specific exceptions may still apply, may still justify a warrantless search of a particular phone. One well-recognized exception applies when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. Now, I'm just going to ask you to put another cross-reference in your notes here. This is going to be the holding of the New Jersey Supreme Court in a case called State versus DeLuca, dealing with pagers, which we'll get to in a second. But I just want everybody to see DeLuca, what was in play in DeLuca, ultimately was the exigent circumstances exception. Such exigencies could include the need to prevent the imminent destruction of evidence. One answer to the question of what the police must do before searching a cell phone seized instant arrest is accordingly simple. Get a warrant, all right? How hard could that be? If you're a prosecutor, what should we seized the cell phone, we want to see what it says. What should we do? Develop probable cause and get a warrant, all right? Here's the citation in DeLuca, and DeLuca, we don't have any New Jersey cases at this point dealing with cell phones, but DeLuca's an older case dealing with a pager. Police arrested the guy, seized the pager incident to an arrest, and started looking at numbers, and that kind of advanced an investigation they were undertaking. I forget whether it was drugs or homicide, but it was significant. The exception in that case was the exigent circumstances exception, which justified that search. So, in a sense, the Riley case really kind of underscores the ability of the police to use that exception, and it was held to be appropriate in the DeLuca case. DeLuca is about the closest thing you're going to come to the Riley case in New Jersey. If you want to start writing a brief on this, though, you certainly want to look at DeLuca. Although, again, they were able to bypass the warrant requirement based upon exigent circumstances in DeLuca. All right. So, I want to switch gears here for a second. This is another Justice Scalia opinion, United States versus Jones. And I made a reference to this before, that this is actually one of those situations where the court finds guidance and how this would have been treated in colonial times, in the founding era, so to speak. This case is a straight up, I guess, they say to themselves, what would the founders have, how would they have ruled, how would they have looked at this issue? Now, I want to give you a kind of introduction. There's a little video clip. Can we show this? All right. This is a clip for a movie that I'm sure you've all seen. It's a Jimmy Cagney special. It's from 1949. And I want you to take a look. The director spent an enormous amount of time in the movie demonstrating this police technology. And for a 1949 audience, this was like some whiz-bang stuff, okay? But I'll tell you a little bit more about it. Let's take a look.
What are you doing? We're on our way. You gotta have a chain bouncing the ground, get rid of electricity.
That's only when you got gasoline or chemicals floating around inside.
You wanna have some traffic cop think you got a load of something else?
That's using your head, kid. All right, snap it up.
Got him. This is Car A in La Canada, Verdugo. Receiving signal 105 degrees. We'll repeat 105 degrees.
Check. Come in, Car B.
Car B bearing 284 degrees.
Main and Atlantic, Alhambra, general direction southwest.
Main Atlantic in Alhambra, general direction southwest.
Get the idea? This is 1949. Now, Jack, you'll remember this. This is exactly the technology that the Allies used in World War II in the Battle of the North Atlantic to hunt down U-boats. And early on, before the Germans figured it out, they would, be broadcasting their location and things of that nature. But through triangulation, they'd have listening posts on ships and on, Greenland and Iceland and places like that. And they were able to kind of pinpoint the location of the U-boat from its last signal and then send attack ships to try to sink it. Later on in the war, the Germans kind of caught on to what they were doing and developed this. I know there's got to be a radio guy here somewhere can explain this, but there's a pulse type of communication where they were able to send out just like one little micro dot blast of information that would go back to, from the U-boat back to Berlin. And it eliminated the necessity to be on the air for a long period of time. It was just like that. And this package of information would go back, and pretty remarkable stuff actually given the era, but in any event. So that's the technology we're talking about, but let's move the clock ahead to 2012 because people don't rely upon this type of technology. Now it's not necessary to follow these people around. You can just put a GPS device on their vehicle and then forget about it for the next 30 days. The computer will do all the work, show you exactly where the vehicle has been, how long it's been there, and can just give you either real-time or past updates about the activities of the vehicle. The question in Jones was whether or not putting this device on someone's vehicle constitutes a search within the meaning of the Fourth Amendment. Now again, it's very simple. If it's a search within the meaning of the Fourth Amendment, the cops have to act reasonably, meaning get a warrant or utilize one of the exceptions to the warrant requirement, exigency, consent, whatever it may be. If it's not a search within the meaning of the Fourth Amendment, the cops can do whatever they want. The reasonableness doesn't enter into it, okay? Because they only have to be reasonable when it's a search. So what happened in this case was the FBI was looking at a particular guy. They wanted to follow him around. And they went to a federal magistrate in Washington, D.C. and presented an affidavit of probable cause and asked for permission to put a GPS device on this guy's car, okay? The magistrate read over the affidavit and signed a warrant authorizing the FBI to put this device on the guy's car. Now there were some restrictions on it. Like most search warrants, it has a very short time period. In this case, it was 10 days. And also, it had to be installed within the territorial jurisdiction of the court, meaning Washington, D.C. So the warrant says, go ahead, put it on. You've got to do it in the next 10 days and do it within Washington, D.C. So the FBI goes forward and puts the GPS device on. Unfortunately, they put it on the 11th day and install it when the vehicle's in Maryland. Don't! But other than that, they followed the warrant perfectly, okay? So they follow the guy around for a while and gather up all the evidence they need, and they're able to arrest him and prosecute him based upon this GPS tracking that they engage in. And of course, the motion to suppress is that you didn't have jurisdiction from a warrant because you didn't follow the procedures, okay? So the FBI, through the U.S. Attorney, resorts to Plan B. And Plan B is, what warrant? We don't need a stinking warrant. This is not a search within the meaning of the Fourth Amendment. Since it's not a search within the meaning of the Fourth Amendment, we don't need to get a warrant, okay? Now remember, persons, houses, places, and effects. What did the FBI do here? They went and literally trespassed on this guy's car by touching it. An effect would have been understood at the time of the framing to include such things as automobiles, motor vehicles, okay? They went and basically trespassed on his car, his effect, by installing this GPS. That would have been understood at the time of the framing of the Fourth Amendment to have been a search within the meaning of the Fourth Amendment, meaning now that the police have to act reasonably. So utilizing a GPS on a vehicle is a search within the meaning of the Fourth Amendment. Let's take a look at the holding of Jones. Government's attachment to a GPS vehicle and its use of that device to monitor the vehicle's movement constitutes a search under the Fourth Amendment. The Fourth Amendment protects the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Here, the government's physical intrusion on an effect, the car, for the purposes of obtaining information constitutes a search. This type of an encroachment on an area enumerated in the amendment, meaning effects, would have been considered a search within the meaning of the Fourth Amendment at the time that it was adopted. I mentioned two older cases here involving beepers that were put inside of, surreptitiously inside of contraband that was being transported around the country by the FBI, Cairo and Knotts. I'm not sure that they have any particular relevance anymore, but if you have to write a brief, I wanted you to be able to read them to see if there's anything helpful in there, okay? Let's move to the New Jersey side of the street here. I want you to take a look at more advanced technology. This is something that's going to come up in the next case.
Still on tower 3. 5. Signal getting stronger. 10. 15. Keep going. 20. 15. 10. Signal's getting weaker. We lost him. No signal. Heading south. He's up at 5 again. 15, 20. He's moving fast. He's in a vehicle. Weaker now. He shifted. We're back to 5.
He's close by here somewhere. I don't get it.
He's driving in circles.
No change? No.
Now let's hope he comes back around.
Okay. 15. 20. 30. 40. 50. We're within 10 meters of it. Back to 40. He's here somewhere.
Look at the cars. Look at the cars. He's in the vehicle. The guy with the phone in the white car. You see him? Is that him?
Could be.
You got him?
Got him.
Okay, breaking up.
This is exactly the technology that was utilized by the police in State versus Earls, okay? Cell phones, pings from cell phones. The stronger the signal got, you heard him say, is 30, 40, 50. This means that the strength of the signal they're getting is increasing. The higher it goes, it means the closer. It's an inverse relationship. The closer the guy is to them physically, okay? Let's talk a little bit about what happened in the Earls case. Let me flip over to Earls. You know, those of us who do criminal work, I know you've all had this experience where you get criminals that are really good at what they do. You have to admire them in a way, you know. I have a lawyer I represented one time on an ethics thing, and he ran some kind of an unbelievably complex scam that they unraveled. And he wound up getting suspended for a couple of years, but they took him back. And this guy is so smart and so devious, they will never catch him again. Just never. There's no possibility of them ever figuring it out, okay? And you get clients that are just like they're really good criminals. So this guy Earls, he's one of these guys. He's just an unbelievably great thief. And he's also one of these guys you see on the reality TV shows. He's a hoarder, you know, like keeps everything in his house. So he's such a good thief and such an inveterate hoarder that his house where he lived in you couldn't get into it anymore. It was so full of stuff that he had stolen that you literally couldn't get in the front door, okay? So he goes to his girlfriend and advises her that it would be a good idea if she went out under her own name to rent one of these storage locker things, okay? Which she does do in her name. Gives him the key, and within a very short period of time, he fills this up to the rafters with stuff, okay? So now, he still has no place to live because his regular house is full of all kinds of stolen stuff. So he decides he's going to rent some cheap motel, which he immediately begins filling up with all kinds of stuff. Now the cops, needless to say, know they have a maniac on their hands, and they're working this case hard, okay? So during the course of their investigation, they discover the girlfriend. They bring her in, and they start to, for want of a better expression, lean on her, as only the police can do, okay? And you guys can fill in your imagination about what it meant to lean on her. So she gives up the storage locker, takes him over there. She consents to opening up the locker. The police see and recover a lot of the stolen stuff from the locker. And the police say to her, all right, where is he? We want to have a chat with him. Because this gave him enough evidence to get a warrant for his arrest. She said, well, I don't know where he is, but look, I got his cell phone number. Why don't I just call him up and tell him to surrender? The police said, no, we don't think that's such a good idea, but we'll call him up. We'll ask him to come in and surrender. What's his number? So she gives him his cell phone number. So the police know that he's got T-Mobile as his server. So the police call up T-Mobile, and they say to the T-Mobile people, look, can you tell where this particular cell phone is located right now based on its pings? And T-Mobile says, yeah, we can tell you right away within a couple meters because of this triangulation business based on the pings of the cell phone. It pings apparently every 7 seconds. They give the cops a location, and the cops, acting on that information, flood the area with cars, but they don't see him. The police call back 2 hours later, go through the same process. T-Mobile does a triangulation search, says, okay, the phone is at this particular location now. Cops flood the area again, still can't find the guy. Victor, I say this with all due respect, but this illustrates what's wrong with New Jersey police. Double A, what's wrong with New Jersey police?
Too suspicious.
And?
I digress.
Too persistent. I would have given up after the second time. I mean, look, second time he's not there, I'm off to Dunkin' Donuts. I'm sorry, but it's the way. Not these cops. They call back a third time, all right? So they get another location from T-Mobile. This is all going over the period of like 4 or 5 hours. So the cops flood the area. They see the guy's car parked outside of a motel. So the police go with a picture of him. They have a warrant for his arrest. Take the mugshot, show it to the Indian guy who's running the motel. Oh yeah, he's in room 3. Knock on the door. He answers the door. They grab him, they see all the stuff he's got in his motel room, and they're able to recover all that stuff, okay? So now the issue in this Earls case is the reasonableness of the police, without any judicial involvement at all, utilizing the pings coming out of this guy's cell phone. So the appellate division, this is one of the few times I've ever been right in predicting how the Supreme Court's going to rule in a case. The appellate division comes out and they said, look, you have no expectation of privacy for being in public. When you're driving around in public, you know, people can follow you, track you, and the fact that the police are using this pinging as an adjunct to their eyes and ears to follow you around in public, it's just not a Fourth Amendment issue. You have no expectation of privacy. If you have no expectation of privacy, it doesn't constitute a search within the meaning of the Fourth Amendment, and as a result, the police can do whatever they want. They don't have to act reasonably. And I'm reading over this psychobabble that the appellate division is saying. I thought to myself, the Supreme Court of our state is never going to countenance this type of a search. It's just not going to happen. And I was right for once. I have to tell you that the Earls decision is probably unique in the annals of Fourth Amendment jurisprudence in the United States. I don't know that any other court at this point has had the occasion to rule on this particular issue, but it will certainly be good precedent for the rest of the country. Let's just take a look at what they say. Applying those principles here, we note that disclosure of cell phone location information, which cell phone users must provide to receive service, can reveal a great deal of personal information about the individual. And remember, we're just talking about the pings out of your cell phone that go to the tower so they can figure out where you are. With increasing accuracy, cell phones can now trace our daily movements and disclose not only where individuals are located at a point in time, but also which shops, doctors, religious service, and political events they go to, and with whom they choose to associate. Yet people do not buy cell phones to serve as tracking devices or reasonably expect them to be used by government in that way. No, we get Easy Pass for that purpose. We therefore find that individuals who have reasonable expectation of privacy in the location of their cell phones under the state constitution. So this is decided under Article 1, Paragraph 7 jurisprudence, not under the Fourth Amendment. We also recognize that cell phone location information can be a powerful tool to fight crime. This is a mistake, it should be those data, will still be available to law enforcement officers upon a showing of probable cause. To be clear, the police will be able to assess cell phone location data with a properly authorized search warrant. I imagine something like a communications data warrant or CDW would be sufficient. Just some type of judicial intervention, judicial authority would allow the police to do this upon a showing of probable cause. And the state could show that a recognized exception, which is going to be exigent circumstances usually, to the warrant requirement applies, such as exigent circumstances, then no warrant is needed. Okay? So keep this in the back of your mind in terms of how New Jersey views this. This is just one step removed from the Riley decision dealing with the actual content. Here's Missouri versus McNeely, which we made a reference to a few moments ago, and I just want you to take a look at the public policy and how the court really is committed to evolving technology. Notice they say the federal rules of criminal procedure were amended in '77 to permit federal magistrates to issue a warrant based on sworn testimony communicated by telephone. Double A, what year was Valencia, State versus Valencia? 80 what? Was it 83?
83.
83, okay. So our own telephonic search warrant jurisprudence did not come along until 6 years after the federal government had already done it. Remember that Schmerber is 1966, so this is Schmerber's happening 11 years before the first telephonic search warrants federally had been authorized, and New Jersey didn't come along for 6 years after that. As amended, the law now allows the federal magistrate to consider information communicated by telephone or other reliable electronic means. States have also innovated, while the majority of the states allow police officers and prosecutors to apply for search warrants remotely through various means, including telephone or radio communication, electronic communication, such as email and video conferencing. There's a footnote there, and they cite New Jersey as one of those cases, probably based on Valencia and Rule 3, I think it's Rule 353B. And in addition to technology-based developments, jurisdictions have found other ways to streamline the warrant process, such as by using standard form warrant applications for drunk driving investigations. Adopting the state's per se approach would improperly ignore the current and future technological developments in the warrant process and might well diminish the incentive for jurisdictions to pursue progressive approaches to warrant acquisition that preserve the protections afforded by the warrant while meeting the legitimate interests of law enforcement. So as we go into the future, adoption of new modes of communication, new interfacing between the judiciary and law enforcement, they're all over that, as you can see. Maryland versus King is also an enormously important case. It should at some point result in some fairly radical legislation in New Jersey based upon what we have now. Let me give you the facts of Maryland versus King. There was an aggravated sexual assault of a woman in her house, a burglar coming in, sexually assaulting her, and then taking off. These are very difficult crimes to solve, especially when you're dealing with strangers that are the perpetrators. So there's really no tie between, it's just a random attack, basically. So the only thing that the police had by way of physical evidence was DNA that they took from her body. So they had, to a certain extent, had forensic evidence. But just that's all they had, nothing else. The police take the DNA, convert it digitally to its recognizable components, and store it in this database called CODIS, C-O-D-I-S. CODIS is the national database used by law enforcement authorities from the entire country. All the DNA that's taken gets converted to a digital signal and put into the database, okay? So as a result, when the police grab DNA from somebody and they're looking for DNA that was taken from crime scenes, it's just a matter of seconds before you have a link up between the DNA, because remember, these are unique markers for human beings. 7 years after the fact, the defendant, King, is arrested on a weapons violation, possession of some type of a long-arm rifle. That is an enumerated offense under Maryland law, which authorizes the police to take a DNA sample from the person at the time of the arrest. In other words, as part of the booking procedures, just like giving your fingerprints, name, and social security number, the police are allowed to go into the individual's mouth utilizing a technique referred to as a buccal swab. Swab out the inside of the mouth, take a DNA sample, and send it over to CODIS, okay? Now remember, we're dealing with people who have just been arrested, not convicted of anything, just arrested, and arrested for certain serious enumerated crimes under the statutory scheme set up in Maryland. The DNA sample goes to CODIS. CODIS gets a hit that whoever they've arrested just now, his DNA was found inside the body of this woman on the day that she was subject to a sexual assault. The police are able to utilize this as a starting point, get some additional information together, and are able to prosecute him on the basis of the CODIS hit for this aggravated sexual assault that had occurred years before. So the legal issue here is whether or not it is reasonable for the police to be able to take a DNA sample from someone they've merely arrested, as opposed to people who've been convicted of some type of a criminal offense. And again, remember, this is done under a statutory scheme in Maryland. Police are acting under, statutory law. Now, in New Jersey, we take DNA samples from people who have been convicted of criminal offenses, 4th degree and higher, after they've been convicted, of course. We also take it not only from adults, but from juveniles who have been convicted of analogous types of offenses in the family court. And that's perfectly fine. We do have a limited authority statutorily for the police to take DNA samples from people who have been charged with homicide offenses as well as sexual assault type offenses, but only as a condition of their release. It's not that it's taken during the booking procedures, but if they post bail before they're released from custody, the police are allowed to take a DNA sample from them, okay? So we have an extremely restricted ability by the police to get DNA from people short of a conviction. They're not going to be able to do it, all right? So now the question before the United States Supreme Court is a weighing process. What is the intrusion on the individual's privacy by utilizing a buccal swab to take a DNA sample versus, on the other side, the societal good that that information is going to reveal? So what is the buccal swab? It's painless. It takes just a second. It's no more intrusive than having the person open his mouth momentarily. There's absolutely no pain associated with it at all, unlike, for example, taking a blood sample from somebody in the drunk driving context. What is the utility to law enforcement? Well, there's a utility not only to law enforcement, but also to the judiciary. You're going to know with absolute certainty who the human being is that you have standing before you. Look at all the good that comes from that. From the judiciary's perspective, you can make intelligent bail decisions. When you're sentencing, you can make intelligent decisions in terms of where this person should be, what should be the level of his custody or her custody. You will be able to clear individuals who have been wrongly accused or falsely accused or mistakenly accused of criminal offenses. It will help identify individuals who committed offenses that were for years and years and years unsolvable. And by the way, the Supreme Court goes on to say that, it's not necessarily that people have been arrested who are giving DNA samples for serious crimes. And they point to 2 or 3 situations where people who were arrested for very minor offenses. They point to Timothy McVeigh, the Oklahoma City bomber. He was stopped for a traffic offense, and that kind of led ultimately to his downfall, the recovery of him leaving the scene. They point out that the fact that someone's arrested for a minor offense doesn't necessarily mean that he hasn't committed some very serious crime far away you arrest somebody for domestic violence in New Jersey, and the DNA would tie him to a homicide in Kentucky or South Carolina or Colorado or something like that.
Sam had a parking ticket.
Perfect example. They go they're looking for people who was in the area. In the Yonkers, they find a parking ticket. Same principle though. Minor offenses can sometimes lead to the apprehension of people charged with very, very serious offenses. Okay. So when you weigh the societal good, the good for law enforcement, the good to society, the good to the judiciary, versus the momentary minor intrusion of a Q-tip into your mouth to extract the DNA evidence, there's really nothing that is unreasonable about that in the context of the Fourth Amendment. Now, the exception to the warrant requirement here is it's kind of sui generis. It's its own exception. It's called the booking procedures exception to the warrant requirement. And that really knocks out of the box any Miranda right you would have to remain silent, because you really have no right to remain silent with respect to providing pedigree information, your true name, your social security number, and your address, health issues related to the need of the police to take care of you in case you have some type of health issue. None of this is protected by Miranda. Miranda wouldn't serve any useful purpose, because the whole purpose of the questioning has nothing to do with guilt or innocence. It has to do with booking procedures. Same thing with photographing you, the mugshot, fingerprinting you as part of the booking procedure. All these things come within this exception to the warrant requirement. And be mindful also of the significantly diminished expectation you have of privacy after you've been arrested for some type of an offense. Okay? Now, that's the good news. Here's the bad news. It's not a particularly well-written decision, because the court is never clear about how serious the offense should be for the arrest before the police, it would be reasonable for the police to take DNA from you. Their holding essentially is that when the police have arrested someone for a serious offense, it is reasonable for the police to take a DNA sample from that person, okay? But they don't define what a serious offense is. Now, I think you could make the argument in New Jersey that if you're talking about anything from the fourth degree and higher, something that meets the actual technical definition of a crime, that's a serious offense. Reasonable people could differ and say, no, serious offense means second degree or higher. At some point, I guess, either the legislature or the Supreme Court will decide that particular issue. Does serious offense also subsume DPs, or petty DPs, or certain DPs, domestic violence, things of that nature, assaultive type conduct, offenses involving violence? Or would it involve drunk driving? These are issues that really have to be answered another day. The court really kind of ducks the issue or creates a little bit of confusion about whether they're subsumed under the general rule that they cite here. All of these things are going to have to be answered by the legislature at some point, because now they have an excuse to go forward and set up a statutory scheme that will allow the police to take DNA samples from individuals who have been arrested, at least for serious crimes, whatever that may mean. I would hope simultaneously that they'll set up some type of procedure so that if the defendant's acquitted or they wind up dismissing it for some reason, that when the defendant goes for his expungement, he'll be able to include the DNA evidence that was taken. Right now, there's nothing in the expungement statute that covers DNA. They mention fingerprints and all the post-arrest stuff, but there's nothing in the statute that allows for DNA to be isolated like the other types of things that you have. So here's the holding in King. When officers make an arrest supported by probable cause to hold for a serious offense and bring the suspect to the station to be detained in custody, taking and analyzing a cheek swab of the DNA, if the DNA is, like fingerprinting and photographing, a legitimate police booking procedure that is reasonable under the Fourth Amendment. Okay? The framework for deciding the issue is presented and well established. Using a buccal swab inside a person's cheek to obtain a DNA sample is a search under the Fourth Amendment. The fact that the intrusion is negligible is of essential relevance to determining whether the search is reasonable, the ultimate measure of constitutionality of governmental search. Because the need for a warrant is greatly diminished when the arrestee is already in valid police custody for a serious offense supported by probable cause. See, this is the problem with the case, that wording. The search is analyzed by reference to reasonableness, not individualized suspicion. Reasonableness is determined by weighing the promotion of legitimate governmental interest against the degree to which the search intrudes upon the individual's privacy. And once again, this is the same issue that our Supreme Court's going to have to consider in the Verpent case that we talked about a little while ago, dealing with taking urine out of individuals who've been arrested for drunk driving. In this balance of reasonableness, great weight is given to both significant governmental interest at stake in the identification of arrestees and DNA's identifies unmatched potential to serve that interest. But again, this is all digital. The court, they want to decide the case on as narrow grounds as possible, and the Maryland scheme was limited to certain serious offenses that were either, for the most part, delineated in the statute, but they were, homicide and sexual assault and weapons offenses. It wasn't every single offense, okay? So I don't think they wanted to go beyond the parameters of the statute that was right before them, which limited itself to serious offenses. One of the rules of, Supreme Court, so to speak, is they don't try to go beyond, what's on the plate before them, okay? All right. We have to talk for a few minutes about access to digital information, electronically stored information, okay? And here, the federal government and the New Jersey Constitution are 100% at opposite poles, okay? I suspect within the next decade, there's going to be a major change in the law federally, because I think the Supreme Court reads the newspapers too, they follow the election results, and they know when the public gets outraged, it may be time for a change in the law. Let me give you an example. Straight up black letter federal law is that you have no expectation of privacy in information that you voluntarily turn over to a third person. That's just the way it is, okay? I'm not saying it's right or wrong, I'm just telling you that's what the United States Supreme Court says. If you have no expectation of privacy, then when the government starts looking at it, it's not a search within the meaning of the Fourth Amendment, meaning that the cops can do whatever they want. They can get access to that in some way short of presenting a search warrant or relying on some expectation or some exception of the warrant requirement. We saw this come out, I guess it was last year, in a very, very kind of an outrageous controversy dealing with the so-called metadata that had been secured through the activities of the National Security Agency, the NSA. And you saw that they took millions and millions and millions of telephone records and were analyzing them in order to spot patterns and things of that nature. And as much as they tried to downplay it and talk about how this was not an intrusion of anybody's privacy and things of that nature, once again, reasonable people can disagree about that. My sense is that there was a huge public outrage that they were involved in this. At least that's my sense of it. The court, the NSA was able to get away with this, in fact, able to obtain the information just based upon subpoena with no articulable suspicion at all, because you have no expectation of privacy with respect to this information. It's in the hands of a third party. It's not a search within the meaning of the Fourth Amendment. Smith versus Maryland and United States versus Miller are the two main cases dealing with this issue. Miller in particular deals with banking records, okay, electronic banking records. Your checks, your canceled checks, the checks you wrote to different individuals that are in the possession of your local bank. You have no expectation of privacy in that information. The police can just go in and get it or get a subpoena for it without any showing of probable cause because you have no expectation of privacy, okay? Now, having said that, take a look at New Jersey. The law in New Jersey is exactly the opposite. In New Jersey, you do have an expectation of privacy with respect to information that you voluntarily place in the hands of a third party, okay? So when the police want to get that information, since you have an expectation of privacy, it constitutes a search within the meaning of the Fourth Amendment. They're going to have to act reasonably, get a warrant, grand jury subpoena, Superior Court, criminal action order, something of that nature. Here is a restatement of the law. New Jersey accords substantial expectation of privacy in electronically stored records in possession of a third party. As a result, unless there has been a voluntary consent or some demonstrable exigency, the police will need some form of advanced judicial authority to obtain these records in the form of search warrant, grand jury subpoena, criminal action order. Now, this is something that didn't happen yesterday. We've had this in New Jersey for a long time. One of the earliest cases distinguishing the Article 1, Paragraph 7 from the United States Fourth Amendment is Hunt dealing with your expectation of privacy in telephone records in possession of the phone company. Federally, you have no expectation of privacy. In New Jersey, you do, based upon the Hunt decision. McAllister is New Jersey's version of the United States versus Miller case, dealing specifically with banking records. And the ruling by the Supreme Court of McAllister is you do have an expectation of privacy in your banking records. New Jersey police are going to have to get a search warrant if they want to look at it. Domich, which, by the way, when you read Domich, you should just, I commend it to everybody just for entertainment purposes. It's literally one of the most entertaining cases you'll ever read. Just to give you a little bit of background about Domich, the actual issue in the case dealt with obtaining records from Public Service Electric and Gas about an individual's use of electricity in his house. Why? Because the police thought he had a marijuana farm in his house, and they wanted to look at his power usage to see if it was consistent with somebody who had a lot of these glow lights or grow lights in his house. You know, I guess they use up a lot of electricity. So that's how this kind of came up. But what's interesting to me about Domich is that the appellate division believed that the guy was innocent, okay? That the jury that convicted him got it wrong. They thought a miscarriage of justice had been done. But they can't overturn a jury verdict. I mean, they can't. The jury heard the evidence and they said guilty. But they think the guy's innocent. So what they do is they come up with 6 preposterous arguments, and they are preposterous, about why this guy should be let out, okay? Just to show you the extent of it, one of the things the police do during the course of their investigation, again, because they're checking it for a marijuana farm, is they get one of these devices that can look into your house to see hot spots, you know, to see if there's like heat sources inside of your house. And this is an issue that actually went to the Supreme Court of the United States. I forget the name of the case, it doesn't matter, but the United States Supreme Court held that this is a search within the meaning of the Fourth Amendment. And the appellate division in this Domich case says, see, you police went to that house and used this heat-seeking device to see whether or not he was doing that. Now, we understand that this all happened 2 years before the United States Supreme Court decided this case. But as good police, you should have anticipated how the United States Supreme Court would have ruled and not used that device without a search warrant. I'm not making this stuff up, but you got to read this stuff. It's the craziest stuff in the world, that the police should have anticipated how the Supreme Court was going to would have ruled in that case 2 years before the court ruled, and many months before the case was even on the horizon before the United States Supreme Court. So they really kind of stretched the envelope, so to speak, to find this guy not guilty. It went to the New Jersey Supreme Court, and they reversed every one of these 6 justifications for letting this guy out of jail. But the bottom line, and for our purposes here, there is an expectation of privacy in the billing records that are associated with electrical use. Reed is a case involving internet subscriber information. Here the police, once again, were investigating a theft. They thought that the person had utilized a computer to perpetrate the theft. They called up Comcast on the phone and asked for information related to this person's internet subscriber information, which Comcast was only too happy to give them. I think their justification for it was they had a subpoena from the municipal court administrator. Of course, the subpoena was returnable on a day that the court was not in session and involved an offense. It was outside the trial jurisdiction of the municipal court. Otherwise, it was perfectly valid. In any event, the New Jersey Supreme Court in Reed rules that the people have an expectation of privacy with respect to their subscriber information, and if the police want that, they're going to have to get a search warrant. State versus Earls, you just saw the latest iteration of this, dealing with the cell phone signal tracking as we saw in the movie. Now, one case is a little bit of an exception to this, is State versus Sloan. Here's what happened in Sloan. The cops do an MV stop, and while they're processing the ticket for the driver, they start asking people questions in the car like, what's your name? Is it Mary or Sue? So the front seat passenger gets asked this question. Stupidly, he gives his true name. The police then do an NCIC search, over the radio, and they get a hit. There's a warrant for this guy. So they yank him out of the car, tell him there's a warrant, search him, it's into the arrest on the warrant, and find drugs in his possession. Duh, what a shock. So now the motion to suppress is, hey cops, why are you running my name through NCIC? I didn't do anything wrong. You had no articulable suspicion to run my name. I'm just sitting there like a schlub as a passenger in a car. I wasn't responsible for the car getting stopped. I'm just there along for the ride. So now the issue before the Supreme Court is a search of NCIC records, a search within the meaning of the Fourth Amendment. Do you have an expectation of privacy in your NCIC records, okay? Here's the easy answer. If you have an expectation of privacy, the police have to act reasonably. Get a search warrant or have some exception. If you don't have an expectation of privacy, the cops can do whatever they want, all right? The New Jersey Supreme Court held that NCIC records are there for police use to find fugitives, stolen cars, firearms, to locate missing and endangered people, and quite a number of other functions. Society is not prepared to recognize an expectation of privacy in NCIC records in this particular database. As a result, the police don't need an articulable suspicion, and as long as their search is not going to unduly prolong the traffic stop, there's no problem with the police running the names through NCIC. So that's the holding in Sloan, kind of a little bit of a reversal, but again, based upon no expectation of privacy in a law enforcement database, as opposed to business information you've turned over to a third party. Now, the last thing I want to talk about, it deals with workplace computers, and at this point, the law that's developed is kind of very easy to get your head around. The simple answer is that you have no expectation of privacy in a workplace computer that is owned by your employer, okay? So if your employer buys the computer, buys the tower, provides you with all the information, the fact that you might be on the computer looking at kiddie porn or involved in personal communication or something of that nature, or just engaged in stuff that you would normally want to have remain private, is of no moment. You have no expectation of privacy. Meaning if your boss wants to turn it over to the cops, he doesn't need it. The police don't need any justification if there's going to be a voluntary turnover by the employer. MA is the main case standing for that proposition in the criminal context. In the civil context, same holding, Doe versus XYZ. These are both phony names because it involved child pornography and child sexual assault. But again, this was a situation in a civil context where a computer was handed over on a voluntary basis, no expectation of privacy in workplace computers. Two issues that I want you to be sensitive to, one of them dealing with attorney-client privilege. In the Stengard versus Loving Care, there was a workplace computer clearly owned by the work, but the communications that were subject to seizure dealt with communications between the employee and his attorney. The attorney-client privilege trumped the normal lack of expectation of privacy. You do have an expectation of privacy in your communications with your attorney. That survived this otherwise kind of indelible rule. Here are the federal cases that are the only ones I could find that are in play at this point. Two district court cases, two circuit court cases and one district court case, all saying the same thing, no expectation of privacy in workplace computers. Now, the only issue that I can't get my head around, because I can't find any cases on it, deals with workplace computers that are not owned by the boss, but are owned by you. In other words, you bring your own computer to work, or you bring your own laptop to work and use it as an adjunct to your normal work activities. There may be an expectation of privacy there. I just don't know of any cases. You may want to advocate that if you have one of these cases that comes up. Okay? So, my purpose today was to kind of give you guys a sense of where we are, to understand what the long-term trend is, and the short-term trend as well, and just give you some ideas about how you can start doing motion suppress and running briefs to attack these issues when there's been a seizure of digital information, because more and more into the future, it's not going to be the physical realm, but the digital realm we have to be concerned about. And I want you to all be sensitized to that, okay?